Hello, everyone, and thank you for joining us for this panel discussion. We have a great presentation planned for you all today. First off, I would like to introduce our panelists. My name is Ida Jane Harris. I am an associate in the Products, Environmental, and Mass Torts Litigation Group in Richmond, Virginia, and I will be the moderator for the presentation. Next, we have Anne Bentley McRae. Anne is a partner in the firm's Richmond office, and she co-chairs the firm's e-discovery practice group and manages a team of discovery attorneys at the firm's e-discovery site. Then we have Joan Dinsmore. She is a partner in the firm's Raleigh office. Joan practices in the firm's products liability, environmental torts, environmental and mass torts group. She represents a variety of product liability clients, including a medical device company that she recently represented relating to an outbreak in California. Last, we have Nick Hoffman. Nick is an associate in the firm's downtown LA office, and he practices also in the product liability, environmental, and mass torts litigation group. Like Joan, Nick was on the team that recently represented one of the firm's medical device company clients in relation to an outbreak in California. In 2020, all three panelists, including myself, contributed to Infectious Disease Litigation, Science, Law, and Procedure. This book was published by the ABA with chapters written by scientists, epidemiologists, lawyers, and others. Turning to the table of contents, as you can see, the book ranges in a wide variety of topics, ranging from microbiology basics all the way to jury trials. Today, we'll be focused on two subjects, discovery planning and HIPAA compliance in discovery. Joan and Nick wrote the discovery planning chapter of the book, and Anne and myself contributed and wrote the HIPAA compliance chapter. Let's start off with discovery planning. Joan, I want you to start us off. I know with the COVID-19 pandemic ongoing, COVID-19 is probably the first thing that everyone thinks about when they hear the term infectious disease litigation. Is this a new issue that emerged with the COVID-19 pandemic?
Certainly this is not a new issue. As you asked that question, I thought back to the E. coli outbreak in 1993 that was traced to hamburgers sold at dozens of Jack in the Box restaurants in multiple states. I believe it affected over 700 people, and the company ended up facing hundreds of consumer lawsuits plus shareholder derivative actions. Ultimately, an investigation found that any one of 6 different slaughterhouses could perhaps be the source of the contaminated beef, but it never determined which one. And as germane to this presentation, in my opinion, it was partially because the precise point source was never found that Jack in the Box really bore the brunt of the effects of the litigation in terms of millions of dollars of settlement and hundreds of millions of dollars of reduced sales. So yes, foodborne outbreaks and outbreaks associated with events and venues have been a source of litigation for a long time. What we're seeing more and more of, though, and what the thousands of now COVID-related lawsuits have highlighted, is that outbreaks are often tied to healthcare facilities or medical procedures. The world's attention, understandably, is currently focused on COVID, which really brought to light that nursing homes and long-term care facilities with vulnerable populations and lots of opportunities for cross-transmission on healthcare worker hands and devices, those easily can be the site of some of the worst focal outbreaks. And as it relates to COVID outbreaks, most states have enacted immunity statutes that largely shield healthcare providers from suits alleging that negligence led to an outbreak. But these liability shields are fairly unique to COVID, and I expect that infectious disease litigation will continue to grow in the healthcare space.
Thanks, Joan. You mentioned the term outbreak a few times. Let's break that down. When we hear the term outbreak, what does that mean, and how does it differ from the term pandemic that we've been hearing recently?
Good question. Those terms are easy to confuse. So an outbreak is a greater than anticipated increase in the number of expected cases within a controlled focal location or in a particular defined population. such as patients of a nursing home or diners who ate at the same restaurant on the same day. An epidemic is the term used when an infectious disease spreads rapidly among many people within a region without an identifiable single point source as the transmission pathway for most of the people affected. So there's no real numerical figure that will turn an outbreak into an epidemic. It really has more to do with how specifically exposure risk can be defined. Then a pandemic is declared when an epidemic is spread over multiple countries or continents. So COVID-19 is a great example because it went through all of these phases. Back in the fall of 2019, when it was originally tied to the wet market in Wuhan, China, it was considered an outbreak among patrons of that market. Very quickly, as we know, the coronavirus spread among Wuhan residents several degrees removed from anyone who ever set foot in the market. That turned it into an epidemic among those living in the Wuhan area. Then the spread beyond Wuhan turned it into a pandemic.
Got it. Thank you for that explanation. Before we turn to discovery planning, what types of cases are we talking about when we use the term infectious disease litigation? And can you give us a few example cases?
Sure. So I previously mentioned the Jack-in-the-Box outbreak that led to what was then the largest settlement sums ever paid in foodborne illness litigation. More recently, I'm sure we all remember the successive highly publicized outbreaks led to Chipotle restaurants, and then there was the listeria found in Bluebell ice cream. That led to a huge volume of civil litigation and even criminal charges for Bluebell's former CEO. The 1990s and 2000s also saw some significant litigation related to norovirus outbreaks on cruise ships, infections among guests at weddings and at corporate events held at hotels or large venues. And in all of these cases, there were usually multiple affected plaintiffs and then multiple defendants who could be to blame. Traditionally, and I think I referenced this before, the healthcare field didn't see the volume of outbreak lawsuits that the food industry faced for decades. I think this is because there's some very common bacteria, think E. coli and C. diff, that turn up in the general population with some regularity, so even if they don't cause significant illness to healthy people. So traditionally, when these bacteria show up in the cultures of multiple hospital patients, it doesn't necessarily draw notice of the microbiology lab, especially when you have common infections that are easy to treat with standard-line antibiotics. In the past 10 to 15 years, there have been two major changes that have resulted in increased attention in the legal world to alleged healthcare-acquired infections. So first, there's been a really sharp rise in antibiotic-resistant strains of even common bacteria. So if a cohort of patients who 15 years ago might have all had a C. diff infection that was easily treated with vancomycin, nobody would notice because, unfortunately, most long-term patients end up getting C. diff at some point. But now, if that same group of patients all has infections resistant to most antibiotics, the suspicion for a healthcare-associated outbreak grows, and the exposure risk potential defendants also increases because the patients are less able to recover quickly. The other thing that has made it easier to tie an outbreak to a specific source and increase this litigation in the healthcare field has been the increasing availability and decreasing cost of DNA testing. So now even simple PCR tests can test the relatedness of strains and allow scientists to gauge how likely it is that one person got it from another, and even about when in time the transition happened. For defendants, you've been able to shift the burden back to plaintiffs to prove, for instance, that they got the same E. coli strain as the one present in the contaminated beef in the Jack-in-the-Box example, rather than just saying, I ate there, and proving their entitlement to money that way. For plaintiffs, it's allowed for conclusive scientific evidence of transmission pathways that juries find especially credible. So that was sort of the genesis of this discovery planning chapter.
Thanks, Joan. Nick, let's get into the actual discovery planning for cases involving infectious disease litigation. What are some of the broad discovery planning goals for this type of litigation?
Thanks, Etta Jane. So first and foremost, one of the most important goals for someone taking part in infectious disease litigation is to start thinking more like a scientist. This should actually be a goal for all phases of infectious disease litigation. For that reason, I notice it's the very first thing that Davis Walsh and Sam Terry put in their very great book that we're talking about today. That's the first sentence in the introduction. So now, I come from a bit of a science background, but going through law school and working in other areas since then certainly made me think a little differently along the way. But infectious disease litigation in particular, I found it important to get back to that scientific way of thinking. And even for those who have no science background, I think the detective or CSI type of thinking, when you're essentially working to put together a puzzle or pulling on the thread and seeing what you can unravel, can actually become fun for anyone, and no matter what background that person comes from. So our first piece of advice in discovery planning is to think more like a scientist. And when you first start putting the puzzle together, you might not see the full picture, and it might take a lot of tries before you find a piece that fits. But don't get discouraged and keep thinking inquisitively like a scientist. And so that general principle feeds into our next 2 points. You'll want to obtain discovery to understand the entire outbreak, not just one transmission, and causation rules the day. These points are related, and we'll show some examples here in a second, but thinking about these issues up front during discovery is critical for everything else you do in the case. So unless you obtain adequate discovery on the full breadth of the entire outbreak and on causation, or if you represent a defendant on lack thereof, your chances to succeed on summary judgment or at trial dwindle significantly. Next, bring in experts early where necessary. So although we can try to think like scientists, sometimes nothing beats bringing in an actual scientist to help guide you, or at least provide a high-level roadmap for where you should be taking the case. And just to give you an example, an epidemiologist or an infectious disease doctor may be a big help even early in the case. And finally, be active about HIPAA. As the title of this webinar suggests, HIPAA is a part of the discovery foundation for any infectious disease case. And really, unless you're proactive about HIPAA, you will undoubtedly be working from behind and trying to play catch up with HIPAA later in the case. And I think we all know that's never a fun position.
And speaking of HIPAA, I know that HIPAA is an important consideration during discovery for hospitals and medical facilities. When you're representing a defendant that is not necessarily a healthcare provider, such as a medical device manufacturer, do you still find it important to be proactive about HIPAA?
Thanks, Etta Jane. Absolutely. As Nick alluded to, the main evidence you're going to be collecting or reviewing or producing is going to be personal health information to a large extent, both for the people affected and suing and for other patients as well. So you need to be prepared to address HIPAA issues. In terms of what you're going to produce, a manufacturer has to be aware of HIPAA, because while they are not a covered entity per se under HIPAA, because they're not a medical provider or a healthcare plan, they could be considered a business associate of a covered entity, and business associates of covered entities also have to comply with HIPAA requirements and are often required to sign a business associates agreement committing them to comply with HIPAA and providing for damages and liability if they do not do so, both to the healthcare provider and potentially to the plaintiff or the patient. So you have to keep that in mind from the outset. When you're dealing with requesting documents from patients, from the plaintiff patients, you have to look at HIPAA in terms of getting the authorization from those plaintiffs for their medical records. There really shouldn't be an issue with getting that authorization, since they've put their health care at issue by bringing the lawsuit. But you have to make sure that your authorization is HIPAA compliant. So it has to include the HIPAA statute language allowing for the release, and it has to have a space for the patient to sign the release, or his representative or her representative to sign the release, and the specific healthcare provider or facility and their address. So you have to make sure that you comply with those when getting the plaintiff's medical records.
Thanks, Anne. Nick, can you talk about what it means to obtain discovery on the full scope of an outbreak?
Yes, absolutely. So a single outbreak, as Joan alluded to, may involve different methods of transmission and multiple transmissions, to multiple outbreak patients. And so we put up here on the screen some words that you may be familiar with now in connection with the COVID-19 pandemic. Words like vectors, contact tracing. I know a lot of individuals who tested positive for COVID-19 then had contact tracing performed by their local public health departments, modes of transmission, and epidemiological links. And then we've also put on the right-hand side of the screen an image, which is essentially a map of a hypothetical hospital outbreak, and how it will be mapped with patient 0 in the middle, which would be the initial originating patient with the pathogen, and then, or the index case, and then patients 1 through 11 in subsequent circles, and it's kind of mapped out in the sequence of onset for each subsequent patient. And so this actually is a figure that we included in the book, and this shows how if you represent, for instance, just patient 11, let's say, you might think that it's just your plaintiff involved, and it was just a single transmission and it wasn't really an outbreak. But then if you really investigate the full outbreak, you might learn that there's a number of other individuals in the exact same hospital that got the same pathogen around the same time, and that it actually is an outbreak. And then on the flip side, if you represent a defendant, it's always worthwhile to investigate the full outbreak as well, because you can actually see here that for instance, people were in different floors when they obtained the pathogen, in different wards. They might have come into contact with different healthcare workers. They might have come into contact with different medical devices. And who knows, investigating all these individuals, you might learn something like they all came from the same airplane, or, they all stayed in the same hotel, or all attended the same conference just before this. So that's what it means when you really, determine the who, what, where, when, why, and how of each transmission for all of the outbreak patients.
Thanks, Nick. For these discovery goals you're describing, how do they differ, if at all, for a plaintiff in infectious disease litigation versus a defendant?
So the goals are very similar. For both plaintiffs and defendants, the causation really should drive discovery, and causation really rules the day. That's what it's gonna boil down to on summary judgment. It's what it's gonna come down to at trial if the case goes that far. And so, just to give you an example, if a plaintiff's attorney represents one patient from a hospital outbreak that we showed you on the last slide, and if that plaintiff's attorney doesn't investigate the entire outbreak and just brings one claim, that not only weakens the one plaintiff's claim, since one case is far less compelling than a 10 or 11 person outbreak in a hospital, but also if the defendant then figures out later that there's at least one other patient or other outbreak patients that had alternative routes of transmission, that could essentially destroy the plaintiff's case. And so for defendant, on the other hand, exploring and establishing alternative routes of transmission, or even the possibility of them, can be a game changer. As I explained in connection with the last slide, determining, for instance, that the transmissions occurred not in the hospital, but at a conference beforehand, or even the suggestion that all of the individuals were at a common location before that, or ate at a common restaurant. Those types of things could severely weaken the plaintiff's case. And so then, in addition, as I mentioned, causation will almost undoubtedly be the hot button issue for a summary judgment motion. The defendant will want to claim that plaintiff's expert's opinion on causation lacks foundation, and then plaintiff will want to ensure that his or her experts have provided sufficient evidence of causation to get in front of a jury. And so again, you can't start this process and think about causation or think about the entire outbreak or to try to get discovery on the full scope of the outbreak just a few weeks before you're due to file a motion for summary judgment. You need to be proactive about this and build your foundation. This has to start at the very beginning stages of discovery.
Thanks, Nick. Joan, what types of documents should be targeted in discovery, and how are those documents typically obtained?
So, at least Nick spoke of putting on a science hat and looking at an outbreak as a puzzle, and I completely agree. So for me, I generally find it helpful to understand the outbreak on a macro level before diving into the minutia of the particular plaintiffs who are bringing, or patients who are bringing claims. There's usually multiple sources of information that can be put together like the puzzle pieces Nick talked about, because there's often different entities investigating the same outbreak. They, as we've seen, have different missions, sometimes different agenda. So they all have a different perspective that can be used to piece together information. So a good place to start is often public health agencies, whether they're from the county or the state, or even, depending on the type of outbreak, the CDC or FDA. They usually are coming in to do some type of investigation, and those agencies will generate memoranda, conclusory reports, and those can be immensely helpful in giving you the 30,000-foot view and then piecing together where individual patients fit into that. So very early on, I prioritize getting both subpoenas and public records requests out to any agency or entity that did a investigation of the outbreak as a whole. I like to do this early, both because I like the broad overview and also because, frankly, sometimes government entities can be very slow in actually producing documents after a request is submitted, so I hop on that pretty quickly. So then we start looking at individual causation, like Nick talked about, and many outbreak cases involve multiple defendants who may potentially be adverse to each other when you get down the road. So even if initially you're on the same side of the V, if you're not engaged in a joint defense agreement where you know there's no adversity, you really are, it's to your benefit to obtain formal discovery from co-defendants or third-party discovery from non-defendants who could have been involved in a transmission pathway, and be just as robust in getting that type of discovery as you do from plaintiffs. So one example that Sam, Terry, and Davis Walsh give in the introduction to this book is an outbreak linked to a water fountain at an airport, hypothetically. So in that case, any number of entities may be implicated: the airport itself, the contractor who cleans the terminal, the contractor who installed the water fountain, the fountain manufacturer itself. I'm probably missing some, but those are some examples. So if an airport were to find itself the target of a claim that there was an outbreak related to that fountain, and they never subpoena the installation contractor because the plaintiff didn't sue them, so there's no discovery coming in from them, the airport may never find out that, for instance, the contractor water pressure too low to consistently flush out contaminants. So the airport then finds itself on the hook for liability that it could have gotten contribution for, or maybe even contractually disclaimed through an indemnification agreement. So that is a place I actually go even before the plaintiffs to find helpful information to look at in the context when I look at plaintiff records. So finally, there is the medical records, including microbiology, culture data. That's going to be a huge part of preparing to litigate any outbreak case. And I mentioned before that scientific advances have made it possible and actually critical for both plaintiffs and defendants to drill down on a specific source of a patient's infection. And as Nick referenced, these advances mean there's this whole new world of evidence to amass and analyze. And unlike in other types of litigation that often involves the personal medical information of not just the plaintiffs, now we have these other potentially exposed individuals that are, again, these little pieces of puzzles. So the claimants themselves usually will give you medical records, or they'll sign an authorization allowing opposing parties to get the records directly. But there's no avenue for that when talking about non-claimants who may be those missing links and whose transmission pathways could be the difference between victory for one side or the other. So in addition to planning for discovery, like you would in any complex personal injury matter, you have to navigate how to get that information you need about those missing links without compromising those other patients' rights under HIPAA. And I know Nick and Ann will talk about that in more detail.
Thanks, Joan. Ann, when you want to obtain all of a patient's medical records, are there any HIPAA considerations as you go about that process?
Yeah, so we talked already about getting the authorization and tracking the HIPAA language in order to do that, but I think you also need to be prepared to defend what you're going to do with all of the information that you are going to amass about both plaintiffs and non-plaintiffs once you have the information. So you need to be prepared from the outset on how you're going to protect information. So the first thing I would do would be to negotiate a protective order and an ESI protocol with the other side that lays out the protections that you're going to provide. It should provide for, when you produce documents, end-to-end encryption. It should provide for a clawback if there's something that's inadvertently produced, because we're all used to a clawback of privileged materials, but I think in these cases you really need to have a clawback for PHI or PII that inadvertently gets produced, because that's going to be a big risk for you in negotiating the protective order. So you want to make sure that you have all of those protections in place before you go and request them, so that when you get that objection from the other side that says we don't want to produce documents related to non-plaintiff patients, you can say, here are all the protections that we have put into place, and we will protect that information once it's produced to us.
Thanks, Ann. Nick, how do HIPAA considerations change when you are requesting records pertaining to a third party that is not a plaintiff in the lawsuit?
So Ann hit on this a little bit, but unlike plaintiffs where they've put their medical condition at issue, you might have third parties involved who are involved in the outbreak but are not specifically plaintiffs in the case. And obviously the equation then changes a little bit, and you'll need to particularly take steps proactively to address HIPAA in order to get any sort of information about these individuals. So, Ann mentioned a HIPAA-compliant protective order. That's going to be critical. And Joan and I are going to speak here in a second about, something that we've seen where we've seen this come into play in an actual practice. So the first step is really get that protective order entered by the court, and then specifically tailor your discovery request to address HIPAA. So this means specifically calling out in your document demands or in your interrogatories and stating, that patient identifying information for these non-plaintiffs can either be redacted, i.e. de-identified in terms of the PHI, or, we would suggest even taking it one step further from that and considering requesting that they substitute any patient identifying information with a pseudo-anonymized patient identifier. And we'll show you what that is in a second, but a patient identifier that is substituted in for PHI, for instance, for these third-party non-plaintiff names, can help you then track that individual across different records that are being produced.
Nick, let's talk about those pseudo-anonymized patient identifiers. How can those help you build your case?
So when you have an outbreak, you'll have varying sets of records, as Joan described. You can have records, for instance, from a public health department. You can have, an individual's medical records. you can have emails, you can have microbiology or culturing data. And so when you get all of those various sets of records, assuming some of them are coming from the same party, let's say that you represent a medical device manufacturer in an outbreak that occurred in a hospital. The hospital will be likely producing medical records, emails with physicians talking about the outbreak patients, culturing data, etc. And if you just request de-identified records for those third parties, you will not be able to track that individual across the various sets of records. You will be able to see, a set of medical records that has, big black boxes on it, but you'll not be able to determine, for instance, how that relates to an email that has that black box, or if it's even a different patient or the same. And so what we prefer doing and what we've done in practice is requesting that the producing party switch out any PHI for a pseudo-anonymized patient identifier that is substituted in all produced records. So that would be, lab results, progress notes, emails, reprocessing data, etc. This provides a means for information to be linked to that same person across all of the various sets. And this also goes back to one of our goals that we stated, which is understanding the full scope of the outbreak, including how many outbreak patients are involved, how those transmissions occurred, the onset of the various diseases, and then also the potential routes of transmission. And so we've put this diagram back up on the screen, and this kind of shows how you could do that if you have the pseudo-anonymized patient identifier. You would not be able to track, for instance, the sequence of the onset without the pseudo-anonymized patient identifiers typically. So, another example is you not be able to see, for instance, that some of the individuals came into contact with, the 5th floor of the emergency department, and then, patient 11 was only in the 7th floor in the cardiology department. And then another example is, let's say that a lot of these individuals came into contact with your client's medical device that it manufactures. You would not be able to track without pseudo-anonymized patient identifiers how that device was actually cleaned. If you had the cleaning log or the sterilization log, and you had those pseudo-anonymized patient identifiers inserted into the log, you would be able to determine if, for instance, that device was cleaned or sterilized prior to use on that outbreak patient.
Thanks, Nick. Anne, how does a party perform pseudo-anonymization of records from an e-discovery standpoint, and what are some of the potential pitfalls?
So everybody's familiar with anonymization, which is, kind of straight up redaction, old school, that Nick referred to, that just allows you to redact, PII or PHI. And that's typically been done, manually throughout the years. But as we've gotten better with technology, we have now have tools that can identify certain types of PHI or PII automatically and redact that information. But when you talk about pseudo-anonymization, then you have to have the extra step of adding in the pseudonym for the patient or a replacement for whatever PHI or PII information you want to replace. So again, this used to be done manually. It was a painstaking process. It was fraught with errors, and it was really expensive for the parties making the production. So there have been tools developed now that can identify those kinds of information and automatically replace them across different data types. You have to look at these products with a critical eye, because a lot of times vendors will tell you that they have products that can do this, but they don't actually work as well as they like to say. So you have to test these products before you use them in litigation. And even once you're using them in litigation, you have to have a robust quality control process to make sure that you are not either over redacting information to make or replacing the information to make the documents useless, or that you're not redacting enough and you inadvertently produce PHI or PII. So there are processes that are out there that you can use to do this. And you can still do it manually. I think you have to look at what you have and see what your volume is. Is it worth the investment in an e-discovery product that's going to do that work for you at a price, or is your volume such that you could do it manually?
And are these de-identification considerations important for both the party requesting records and the responding party?
Yes. So what you want to, if you're the responding party and you have HIPAA obligations, of course you want to make sure that your processes are HIPAA compliant. And as Nick alluded to, if you are the requesting party, you want to make sure that you request the information in the way you want to receive it. So if you want the pseudo-anonymization, you need to ask for it up front, because if the responding party just anonymizes it, then you're talking about redoing a bunch of work, and the court probably won't look at that very favorably if you haven't asked for it in the right way.
Thanks, Ann. Joan, I understand that a few years ago, you and Nick had a discovery situation in a case where all these principles that we've been talking about came together. Can you tell us some background about that case and what happened?
Sure. Yeah, sure. So usually I've been on the side representing the hospital, and so going through a lot of the things that Ann discussed. But a couple years ago, Nick and I were working on a case that involved a cluster of infections of a highly drug-resistant bacteria among 18 patients at a large hospital. And we did not represent the hospital. We represented one of the co-defendants, which I'll get to. But the investigation done by the hospital into the outbreak determined that most, but not all, of the infected patients underwent a particular medical procedure involving the same reusable medical device. The majority of the exposed patients filed lawsuits, and they did a good job covering their bases. They sued our client, who was the manufacturer of the medical device, and they alleged that the device had a defect that prevented it from being completely disinfected. They also sued the hospital, alleging a failure to follow proper cleaning and disinfection protocols, and the manufacturer, they also sued the manufacturer of the machine used by the hospital to perform some automated disinfection steps, which again were casted as product defect claims. So that's the general background of that case.
Thanks, Joan. In that case, why was it important to get records beyond just the records of the named plaintiff?
Good question. So the premise of the patient's lawsuit in that case was that regardless of why the medical was not properly cleaned between patients, it, being the medical device, was the source of the infection. So whether it was because of a defect, whether it was because of improper cleaning, was the point source. But those allegations didn't explain why there were some patients who never underwent a medical procedure with this particular device, or there were a couple that had their procedure after they had already tested positive for the bacteria. So, for example, we knew by reading literature and obtaining some of the public records documents and investigation reports from the hospital, we knew that the investigation had determined that there was one patient who brought the infection to the hospital. They called them patient 0. You saw that in some of Nick's slides. And that patient never underwent the procedure, yet passed to patient 1 and potentially others. The hospital's internal investigation it concluded it was the device, that ended up passing it, but never figured out why patient 0, who never had the procedure, gave it to patient 1. So as part of our defense of the medical device company, we needed records from these other patients, patient 0 and then some of these others who didn't undergo the medical procedure, to see whether and to what extent we could find other sources of transmission between them and some of the plaintiffs, so such as Did they have the same internist that came and saw them every day? Were they housed in close proximity to each other? Were they undergoing other procedures using the same device or scanner? So we had to do this to create questions as to whether the outbreak really was all caused by contamination on this device.
Thanks, Joan. Nick, can you walk us through your client's discovery request in that case and the opposing side's objections based on HIPAA?
Yeah, absolutely. So to address these HIPAA concerns, and I should mention, this was a California case, and in California we also have the California Confidentiality of Medical Information Act, or what we call CMIA. Same considerations, and de-identified information is not included in what's protected. So we like to be upfront and proactive, as we've been saying. This is one example from our various sets of discovery in those cases. We included a specific instruction, to the extent your response to any of the requests herein calls for patient protected or identifying information for any patients other than the plaintiffs in this case, please remove or redact such information and use an appropriate identifier for each patient. So that's a general instruction that we included with all of our sets of discovery that we'd advise. And then in specific requests where we were specifically requesting things that would involve outbreak patients that were not plaintiffs, we also reiterated that same instruction in the actual request themselves. So here's an example, and we've redacted it so that we don't identify the client or the plaintiffs, but one of our requests in this case was please produce the medical records for the 34 patients referenced in the newspaper article as patients identified by hospitals testing positive for the outbreak bacteria. To the extent any of these patients are not plaintiffs in the above captioned action, please remove or redact any patient protected or identifying information. So again, just reiterating that we are not seeking, patient protected or identifying information. And so if it does come to the step where, the other side is objecting and we need to follow up with the court, they don't have that argument that, we're seeking things that are protected under HIPAA or the CMIA. One last example is in an interrogatory, we asked, please identify each patient who has tested positive for a multi-drug resistant organism within 120 days after undergoing the subject procedure at your medical facility from 2010 through the present. And then we put in parentheses at the bottom here, all patient protected and identifying information should be removed and an appropriate identifier for each patient used. So this was these are just examples, but you would find this scattered throughout our, document demands, our interrogatories, and this was really us trying to determine the full scope of the outbreak and putting into practice those discovery goals that we identified earlier. And so here's to give you an example of the response that we got from the medical facility that was the responding party for these requests. So the hospital pointed to HIPAA, not surprisingly, and refused to produce records regarding non-plaintiff outbreak patients, and also refused to use any pseudo-anonymized patient identifiers. The responding party essentially gave us a massive block. I mean, I've only copied a small snippet of the objections that the responding party included. I've copied and pasted here the portion about HIPAA, among other privacy protections that they tried to identify, and essentially refused outright to produce anything. And as a result, this became a pretty long process. But because of these initial steps, where we were diligent and proactive up front, you will see where this is kind of going.
Joan, in this case, did the court allow the hospital to use HIPAA as a shield from responding to the discovery request?
You might be on mute, Joan.
Oh, sorry. Thanks. So the answer is no. So this case, it really highlights the need to get out in front of potential HIPAA concerns early. And as it turned out, and as Nick referenced, the parties had rightly anticipated that this case would involve confidential health information potentially of other parties, non-plaintiffs, and they had entered into a HIPAA-compliant stipulated protective order like one of the ones Nick described, and that covered how such information would be handled. So the court cited that same protective order in refusing to allow the hospital to justify not producing records of non-plaintiffs. The court invited the hospital to remove identifying information before production and assign an identifier to each non-plaintiff, just like we've talked about before. This order, I don't think we would have gotten this order had we not had that HIPAA-compliant protective order entered early on in the case before disputes arose. And then, of course, the proactive steps, we requested patient identifiers, including of the plaintiffs, which allowed us to sort of streamline the process of doing that. And also, Nick very diligently followed up on the request for the records themselves. And so all of this came together to secure this order. So as we go to the next slide, despite the court's order finding that disclosure in the case with identifying information removed would not violate HIPAA, the hospital still failed to produce the records. So, and at that point, the court ordered the hospital to pay $8,000 in sanctions and ordered immediate production of all relevant records, including all records without any limitation related to non-plaintiff outbreak patients. We had been willing to accept things like microbiology culturing data about where the patient was located, data about other procedures, but the court said, no, you produce all of it. So this order ended up being pretty critical in the case because within the records we got, we were able to establish very likely alternative modes of transmission for some of the actual plaintiffs, even those who did undergo the medical procedure that was blamed for the transmission.
Thanks, Joan. Can you talk to us briefly about your process once you receive high-value documents about the outbreak?
Yeah, so it's a broad question. I'm mindful of our time, so I'll sort of give an overview. So this brings us back somewhat to where I started, which is needing to get a 30,000-foot view of the outbreak before you drill down to individual patients. So what I do first is make sure I read reports from the outbreak investigation. I then look up medical literature to learn about the pathogen at issue and read about prior outbreaks of this pathogen. That helps me look for potential and likely transmission pathways that are common for the particular organism. I also, very early on, will engage experts in the field to educate me, but I understand good use of scientific and medical experts would warrant a whole separate presentation, so I won't go into that. Then, to most efficiently use my time and, more importantly, the client's money, I rely on staff to organize the records for me. A lot of times, especially when they're produced from an electronic medical record, they aren't very user-friendly when they're printed out or put into PDF. So our law firm employs staff with medical backgrounds to do some of this. They're really good at sifting through thousands of pages of medical records and distilling them into a summary, like we have a snippet on the screen of what that might look like. We call them medical chronologies. And the chronology, for me, often becomes the single most important document I use in preparing for the litigation. And so it's well worth the time to get in good shape early on because you save a lot of time and money on the back end because you're not looking for the same record among thousands of pages over and over and over again. So certainly there are more steps, but as far as the use of discovery materials, these are the areas I prioritize first in every case.
Thanks, Joan. As we're winding down, I'm just going to summarize some of the highlights of what we've talked about. Some practical points for your consideration. First, do not lose sight of the forest for the trees. Think about and investigate the entire chain of transmission for the outbreak, not just the circumstances of one claimant's infection. Seek high-value documents through both formal and informal discovery. Such documents include, for example, reports of public health agencies microbiology data, medical records, and cleaning logs. Do not settle for basic redactions of patient identifying information. Pseudo-anonymized identifiers allow you to track non-parties across different documents. Do not wait to start the process for getting medical records. As early as possible, discern the identity of key providers and ask for signed HIPAA authorization forms from claimants or their representatives. Lastly, educate yourself about the subject matter, organize the records, and create an all-inclusive medical chronology. Moving on to HIPAA compliance, and we've mentioned HIPAA a few times throughout this presentation, but can you give us a brief overview of what HIPAA entails?
Sure. HIPAA establishes data privacy and security provisions for safeguarding medical information like medical records or other identifiable health information, as well as personal identifying information, just like Social Security numbers, any kind of financial information. And generally, it's divided into two parts. The first is the privacy rule, which protects protected health information no matter what form it comes in. So it could be paper, it could be oral communications, like you can't yell out someone's name in a doctor's office, that sort of thing. And then the security rule, which is specifically designed to protect the security of electronic personal health information.
Thanks, Anne. To close out our webinar, can you please provide some practical considerations that you and your eDiscovery team look at when it comes to HIPAA?
So yes, with this kind of eDiscovery, you have to be very mindful of protecting the information, obviously, and technology plays a vital role in that endeavor. So you want to protect the information as soon as you get it. You want to provide a centralized repository for that type of information that is secure behind your firewall and is not accessible by anyone outside your law firm or your company if you're doing the review yourself. You want to devise a plan to either anonymize or pseudo-anonymize the data, and you want to have that plan executed with a robust quality control process before you produce any documents. On the front end, you want to negotiate an ESI protocol that, as we mentioned before, provides for encryption end-to-end of the data. So you want to worry about your security, but you also want to worry about the security of the data once you produce it to your opposing party. You want to make them agree to also provide the security measures necessary to protect that information. You want to have a protective order that provides that the information is only going to be used for the purposes of the litigation and it will not be shared with others outside of that use. And you want to also make sure that you have negotiated what's going to happen with the data once the case is over. You want to make sure that it's going to be properly disposed of so that it cannot be accessed later. And you want to make sure that the other party certifies that they have destroyed that data. And I think we talked a lot about, so I didn't go into this, leverage the technology for identification and redaction of health information to keep your costs down.
Thanks, Anne. I think we have a question from the audience that I'll pose to you. What are best practices if my company or hospital receives a subpoena and we need to produce records for both parties and non-parties?
I think the first step you would want to take is objecting to that request for non-party information. I know we've talked about the fact that you can't rely on HIPAA, but I do think you have to take the first step of making an effort to protect that information and make sure that you have on record that you are making that objection. But then I'd also open the door to negotiation with the other side about how you're going to narrow the request to that subpoena or discovery request. And also in terms of negotiating the protocol for how you're going to anonymize or pseudo-anonymize that data. And then you've got to look to where your data is within your company or your hospital and where the PHI lies within that data. I know that most hospitals and medical providers have robust HIPAA compliant data storage, but this will involve kind of throwing that aside and letting all of this data exit your facility. So you need to make sure that you know where your PHI resides and make sure that whoever you're providing that information to, be it your lawyer or an e-discovery company, is aware of the protections that have to be in place and the processes for making sure that that PHI is protected. Because you have to worry about, not just the patient's medical records, but as Nick alluded to earlier, there's emails that get communicated about patient information. There's spreadsheets about, that aren't really medical records, but they're more financial information, but they also could contain PHI. So you have to make sure that you are identifying every place that it could lie and that you are instructing whoever is doing that review for you to make sure that it's protected.
Thanks, Anne. I think we have time for one more question from the audience, and I'll pose this one to Nick. What are the best strategies to be sure you are getting the discovery to get the best answer? Do you have to cast a wide net, or can you use strategies to be targeted?
Thanks. So I want to thank our audience for these great questions. But on this one, I would say it's a combination of both. So you obviously, with all discovery, I think want to start out somewhat wide. You want to make sure you don't want to miss anything. And especially in the beginning, you might not know the full scope of the outbreak, and you most likely will not know the full scope of the outbreak. Even the public health agencies, they might have identified outbreak patients. They might not have known about patients that, cultured positive after their investigation. They also might not have gotten into the specific modes of transmission or, looked at alternative modes. So I think you want to start out with some wide document demands, interrogatories, but also mix in some more targeted demands that will enable you to really stand firm on those demands if they're objected to and if you have to move to compel. So I think start out wide and, as kind of like a funnel strategy, start narrowing down as you're learning more and more about the outbreak, and then with your subsequent sets of discovery, you can get more targeted and make sure that you cleaned up everything along the way to understand the full scope of the outbreak.
Thanks, Nick. I think this brings us to the end of our time. On behalf of all of our panelists, I want to extend our sincere thanks to all of you who attended this webinar. If you have any questions, please do not hesitate to reach out to us. Our contact information is listed on this last screen and also on the first screen of the presentation. Thank you.